many charter schools would you say you work for now?
So myself personally, the firm has about 250 charter schools out of the 600 in the state of Florida. Joe Scott is a law firm. They represent Charter Schools USA. They have probably the second largest number of charter schools in the state. They're very involved also in litigation with charter schools, as you know, Charter Schools USA. We have a big, deep bench when it comes to educational matters. Myself, probably about 100 some odd schools represented. Many long-term schools, some are traditional K. I'm happy to provide you a list.
Can you give some examples of the different capacities that you've represented the schools in? What type of matters?
Absolutely, everything and anything. When you represent a charter school, you're representing a small business. So whether it's HR, compliance issues with the district, whether it's real estate, finance, leases, contracts, employee issues, all those things are coming into play. And you'll see the scope attached to my engagement letter. It talks about all the different areas.
So I understand you represent one charter school here in Collier County, is that correct?
Might be two. No, just one. It's Birch Prep Academy.
Okay. How has your relationship been with the district since you started with Bridge Prep?
It's been good. We had a very collaborative effort in getting that particular school open. We had very little issues with the charter agreement. And Collier does a pretty good job with making sure they follow the standard model agreement. We've had no issues in terms of any potential conflicts with that particular school. They were a little bit late getting some of their compliance materials, and Collier worked with them to make sure that was done.
So I'm sure since you've been watching from afar, we are treated very differently than any other charter school in the county. There is a double standard. I mean, you mentioned the model contract. When we went through the renewal in 2017, they were trying to put things into the contract that we said no to, which we had every right to say no to, and they pushed off the vote for another month. They delayed it, saying we didn't reach negotiations. I felt that our attorney at the time did not push back strong enough. I feel in the last year, because of the things the district has done to our school, we did not have much strong support in our legal team. When it came to the district, it was very passive. So I guess my question to you is, in a situation like that, how would you respond to the district that is singling out a charter school and putting expectations on them that they don't put on any other schools?
It's interesting you say that because the parallels with the situation I have right now with Championship Academy in Broward County is almost 100%. 2 weeks after they terminated that charter, another charter came before them that had an SRO missing for 4 days. And instead of terminating that charter because of relationships that they had, they put that charter on a monitoring agreement. And so there's a double standard. The one thing I hate being a lawyer more than anything else is hypocrisy and duplicity. So it's made me very angry. And that's going to come out next week.
Any other questions, board members?
With Bridge Prep, do they have a partner on?
Yeah, their management company, Smart Management.
Okay.
They're out of Miami. They have about 18 schools in the district. The Collier School is struggling a little bit on enrollment.
Mm-hmm.
Their management company is Smart Management.
Okay, and what's your opinion on maintaining a partner? Is that something that Bridge Prep can just decide to self-manage in the future?
They could, and certainly every model out there among charter schools is different, and it depends upon the nature of the school.
Mm-hmm.
Having our firm represent one of the largest management companies in the state, that model works for them. We're also represent schools up in the Plato Academy up in Hillsborough and Allison and Pasco counties. There's 9 schools up there. They they've made the decision to become self-managed. It's not come without litigation, but that's a decision they've made, and they're able to do it. So it depends on the school, and what the model is, and what you're trying to run.
Right. Our application originally was submitted to the district in 2012. Is it a common occurrence to go years later, go back and just amend the application based on how you'd like to operate the school currently?
Absolutely. And I've been involved in schools that have had curriculum changes, overhauls. You have a plan, and the idea is this is what we think is going to work. And then you start actually trying to implement that plan, and things change, relationships change. Charter amendments are one of the main things that I do as an attorney with these districts, and some districts handle it differently than others. Some, like Miami-Dade, makes you go through an entire process and Star Chamber-ish type vote to get the amendment. Some are like, just send us what you want. There's 46 different districts, and they have 46 different ways to handle these things.
Right. And I guess you said you've been following our situation from afar, and do you think when the district via Mr. Fishbane released his report and he had recommendations on how to constitute this board and who should be the replacements for this board, do you think it's in the district has a legal right to demand who's on the board of a charter school?
No, absolutely not. Absent some type of fraud or criminal activity by the nonprofit or something of that nature, I think it's totally outside the district's realm to dictate who should be on the board. That's really up for the school to decide, and how whatever your bylaws say. So I've seen that approach before, and I think it's a little bit aggressive.
Thank you.
Especially with a board that is comprised of everyone from this county. Now, I've seen that happen when you've got boards that are comprised of members from outside the district. So, just want to clarify that.
Is it common for the standard 2-year process of opening a charter school in Florida to be expedited to just a few months?
Absolutely not. Very unusual. Most times it takes 18 months to get open. That's why they changed the law about 4 years ago to have a longer deferment period. I mean, be nice. I've seen it happen. It's not totally unprecedented in emergency type situations, but it's definitely outside the norm.
Have you ever seen a charter application expedited when the school had no campus, no enrollment? What kinds of special circumstances were involved, if you recall, in the expediting of the charter?
One school is an autistic school in Palm Beach, where those parents had made a decision that they wanted to keep their children with that particular staff, and it was an application was taken in a term. Even then, it wasn't a 6-month proposition; it was a year. So that was one circumstance where I've seen it, but they had the students already, and they had a facility already. So that was a long time.
Any other questions?
Yeah.
Mark?
The model charter contract, or the model charter application, does every application is it usually submitted with some type of market demand or market study that there is a need for a particular charter school?
Absolutely, it's part of the model contract. You have to show the area you're targeting geographically, and show some type of study to show that there's a need or capacity to fulfill that geographic area. So, been through many charter school application interviews, and I've seen a few schools go down in flames because they didn't do it.
Because they didn't do a market study?
They just didn't give enough information.
Mm-hmm.
Unfortunately, one of the schools actually cut and pasted the marketing study from a different district, and that didn't go over well.
So in your opinion, if you saw a charter application where it said, lay out the demand or need for the school, and the applicant put not applicable, do you think that would be voted on by a particular district as approved?
Obviously, the district can do whatever they want to do, but that is atypical. And I would think that the district would want to make sure that they're going to approve a school that there was a need for. That's what the application is for.
Any other questions? Okay.
Thank you, guys.
Thank you very much for being here. Is there a motion to approve the engagement letter? It's our new charter attorney.
I make a motion to approve the engagement letter as our new charter attorney.
Any other questions or discussion, board members? All right, all those in favor of the new charter engagement letter, state so by saying aye.
Aye.
Opposed? Passes unanimously. Thank you very much, and welcome aboard. Yep. Drive safely. All right, the next item up is Mr. Whitehead report. Come on down.
I'm not gonna be fine. I believe my voice is loud enough so you can all hear me clearly?
Yes.
I'm not gonna use a microphone, I'll just speak. Is that okay? What you have before you is a copy of some documents that I think it's important that you're aware of the content of these. Because of the nature of this, I also believe it's important that the content of these documents be shared with the members of the Collier County Board, as well as our superintendent and their legal counsel. What this is, it's a notice of an incident under investigation. The agency conducting the investigation, I'm gonna speak about, is the Collier County Sheriff's Office. The date of this report is December 3rd, and it's regarding a violation of Florida Statute 93403, the unlawful recording of someone without their consent. That's what the subject of this is. So the first section of the report, if you'll turn to it, I've highlighted some items. As you can see at the bottom, there's an official case number assigned to this by the Sheriff's Office, so this is a matter under investigation. If you'll look through to the next highlighted item on the report, you'll see up on the top of the page, victim of the incident, and the victim's name is Kelly Lichter, our board president. Ms. Lichter reported this to law enforcement on December 3rd of this year, and I'll give you a synopsis as follows. There was a meeting that was held by phone and by invitation only. Okay, it was run by Mrs. Greer. She had a list of people that she invited to the meeting. No one else other than those on the list were invited to the meeting. After this meeting had taken place, it was discovered that someone had recorded the conversations in this meeting without the consent of anyone in the meeting who was invited to the meeting. So we have a meeting with an expectation of privacy as defined in the statute, and I'll point to that in just a few minutes so you can see that. And yet this meeting took place. As a result of the recording took place. No one was advised of this. Yes, Ms. Miller?
You said without consent or knowledge?
Without consent, that's right, or knowledge.
Or knowledge.
There was no one requested to make a recording, no one gave a permission to make a recording. So the recording was made completely in the dark. We also discovered, and this is listed in this law enforcement investigative report, that a copy of the recording was sent to a state representative, Bob Rommel. I spoke to Mr. Rommel over the weekend, because in the report it states it's believed that Matt Mathias was the person who shared this with Bob Rommel. I spoke to Mr. Rommel over the weekend, he confirmed that yes, that is who it came from. So we have a meeting that was held with expectation of privacy in place, a recording of the individuals in that meeting without knowledge, consent, or permission, and then a copy of this recording sent to a state representative, which now made this item of privacy a public record. So everything you're seeing in the documents that I've compiled are all parts of public record. That's very important. All right, and then if you'll flip to the page behind the police narrative, this is a copy of an email that was sent to Bob Rommel, and it says if you go to the third paragraph, the first attachment is a cut from a recording of a call video conference among a limited number of MCA parents with Kelly Lichter presiding. So, I subsequently learned Ms. Lichter was not presiding. She was not the person inviting people to this meeting. It was done by another parent of Mason named Janet Greer. She confirmed that she was the one who organized and invited people to have this conversation with her. So this is the email, which is a public record document, which defines that this recording was sent and was sent to a state representative's office, which later we learned was forwarded to the legal counsel for the Collier County Public Schools.
Mr. Whitehead?
Yes, sir.
I see that this copy that you provided, the sender of this email to Bob Rommel is redacted, but you confirmed that it is indeed Matt Mathias.
That's according to Mr. Rommel's testimony to me, yes.
Okay.
And again, let me clarify, I'm not conducting a law enforcement investigation on this matter. I'm just verifying facts so that we understand. The sheriff's office is the investigating agency. I'm just reporting to you what's taking place.
I have a question.
Yes, ma'am.
Why would a name be redacted that way in a public records request if it didn't involve FERPA or didn't involve, why would that individual's privacy?
Well, I think that's a question we should ask legal counsel, because Mrs. Lichter's name was not redacted from that.
Right.
Nor is Mr. Rommel's name redacted from that, or any of the other names.
Yeah, actually, I don't, oh, it's not on. Okay, there it is. Actually, to speak on that, I did ask the legal counsel about that, about the redaction, and they too said there should be no redacting of names when there are no children mentioned in these emails. I think that's definitely something that will come up, because it seems like they're selectively redacting names of certain parents, but not all parents. The other thing I wanted to point out, yes, Matt Mathias did share it with Representative Bob Rommel, but there's also a records request where Matt Mathias shared it with parent Jody Bain and asked her to share it with her contact, who is Jim Fox, and also asked to set up a lunch date with him. The other thing I want to point out, when I made a records request for this recording from the district, and it was sent to me by Leanne Zinzer, the file actually says August 5th, private parent meeting. I thought that was very telling.
Yeah, well, there's no question. When we look at the part of the statute, which we're going to come to next, it's very clear, even by law, what privacy means. And the meeting in which individuals were invited to, you were attending only by invitation, this meeting from Ms. Greer, and she made it clear to me when I spoke to her about it, that she invited people, and it was not open to the public.
And Mr. Mathias's privacy was the only one protected.
That's again, that's a item that the school district council needs to answer. They need to answer for that. Because I agree, I don't know why everything else is public record, but not that name. But I was able to confirm it was. So if you go to the next section, 2019 Florida statutes, Statute 93403, the interception and disclosure of wild, oral, or electronic communications is prohibited. I highlighted some sections there. Section C and D under that heading just define what disclosing means, or working or intentional, just gives you some definitions. If you go 2 pages past that, you'll see a highlighted section under item H, Article 1, to intercept or access an electronic communication made through an electronic communication system that is configured so electronic communication is readily accessible to the general public. In other words, you cannot intercept, record, or disseminate this information unless it's some information that was for the public. For example, this is a public meeting. There is no expectation of privacy in this meeting. However, if there's individuals after this meeting who decided to meet in private, where there's no sunshine law issues involved, and they wanted to have a conversation about whatever they want to have a conversation about, that privacy is protected by the Florida statutes. Now, if you go to the next section, highlighted, under item 4A, it states, except as provided in paragraph B, whoever violates subsection 1 is guilty of a felony of the 3rd degree, punishable as provided in Florida Statute 775082. The felony is eligible for a year and a day in prison or more, depending on the type of third-degree felony. So we have an incident which occurred, a parent meeting by invitation. We have a recording of that meeting. And then we have a statute that says, clarifies that action of the recording that took place was unlawful. What we also have is the name of a person who was in possession of this item and sharing this item with others, making this item a public record by sending it to a state representative and to the Collier County Public School System attorney. So what's significant about this individual doing it? Well, if you turn to your next section, there's a cover sheet for the Naples Classical Academy application, which is under consideration today by the Collier County School Board for approval. And if you'll notice, there's something highlighted, Phoenix Education Network. If you go to page 2 of the application cover sheet, you'll see a highlighted name under Naples Classical Academy. One of the individuals requesting or seeking this application approval is Mr. Matt Mathias. If you go to the next section, the Articles of Incorporation confirms the Phoenix Education Network, and he is a voting director in that. Now, what's significant about this and why this needs to be shared with the district is they're contemplating giving an approval of a charter to a group whose principal member is now named in a police report under investigation for an act which is defined by law as a felony. And I would encourage them to postpone any consideration or approval of this until this matter is investigated and all those involved who are going to be charged are known and charged.
I have a question. I haven't looked at the statute probably as in depth as you have. Maybe you can answer it. What I also find interesting is that on August 14th, Fox and Fishbane sent our council a letter. And here's what it says. Just days after the mediation, before the settlement was even inked on August 5th at a parent meeting, the chairwoman accused Mason parents of, quote, undermining the school. So she said, anyway, so the point is now the district is using the illegal recording against the school. Is there some liability with them using the illegal recording?
I did discuss with a private legal counsel this matter to get a clear understanding of the civil ramifications. I know the criminal side of this. And it was explained to me that there are some damages that can be sought from this in civil law cases. Any other questions about this report? Mr. Bolden?
Sure. So the Collier County Sheriff's Office is active investigation, correct?
Yeah.
So do you think because in fact this recording was sent to the district's outside counsel, Jim Fox, and then it was forwarded to the district's internal counsel, John Fishbane, that they will be interviewed?
I think it's very likely that anyone whose name is on this report will be interviewed, because the object of the Sheriff's Department now is one, they'll determine with the state attorney, who I also spoke to about this, Mayor Fox, and she's requested a copy, so I'm sending it to her right after this meeting. They have confirmed that the action that took place is a criminal act. So what they're going to determine now is who's primarily responsible for that, and who are the others involved, and to what level they were involved. So it's a simple, yet there's some complications in the investigation, because they're going to need to interview people in order as they discover names, and more names will surface in this. And typical a type of investigation is one name will lead you to another, which leads you to another, and then you start to learn everyone's involvement in the whole matter. But the Florida law is very clear. Privacy in this state is protected. The only circumstances under which a private conversation can be recorded and utilized for some lawful purpose is one, someone who's in the middle of being victimized with a felony can record that as evidence, and that's a very recent law change, just in the last 18 months or so. And secondly, law enforcement has the ability to do what's called a one-party consent recording, which I have used myself in cases, successfully used, prosecuted cases in which you have a victim and a perpetrator, and the victim has given you consent to record their conversation with the perpetrator, and that has to be done under the supervision of law enforcement, recorded by law enforcement, and then taken into evidence, preserved properly, so that cannot be tampered with or altered under the conditions that law enforcement has to treat evidence. Those are the only two conditions under which someone can be recorded who is in a situation where there's expectation of privacy. Anything else falls under the statute as being a third degree felony. Third degree felony, yes, sir.
Well, I would, I guess, open this up to the fellow board members. Do you think should we, I guess, approve Mr. Whitehead communicating this information to the district?
Can I make a comment to that for you? I actually wasn't planning to ask for permission. I would welcome it. But I think because of the nature of this, there's a responsibility to allow them to disclose this information, since they're gonna make a very important decision about this. So that's why I'm doing clarification on it.
I was just gonna say that I thought it would be irresponsible of us not to communicate this to the district with this important a decision on the table today.
I'd like to say one other thing about this, and this is me editorializing, so I ask you just to think of this as my opinion, this how it impacts the community. When Mason Classical Academy was founded and opened up in 2014, I don't recall anything taking place in which Mason Academy attempted to actively undermine or shut down another school in order to find enrollment. I don't recall anything like that happening. From the evidence I've looked at, it appears that's part of what's in the mix here, very strong evidence to make that very clear. And it looks very bad, I think, to people in the state who support the charter school movement to see some sort of an action like this, which looks almost mobster-like in its impression. It's almost like it's one mobster, is looking at someone saying, I want your business, I'm taking it. Turf war. And it doesn't look good, and for someone to have committed criminal level actions as part of whatever their agenda is. Now, not only is it unlawful, but it looks bad for anyone associated with that organization who this individual represents. Those are just my observations and comments about that. Do you have any other questions I can answer?
Thank you very much for the work on this, appreciate it.
And I'll expedite the dissemination of this information to the parties who need it.
Okay, thank you.
Thank you.
All right, are there any board comments today? Board members?
With the hiring of Mr. Wood with Trip Scott, do you feel that we should perhaps consider sending them a retainer to start things off?
Does he require it? Or they may just be going, we've never, we usually have to do that with this or, yeah.
So, I guess in terms of, if we're gonna consider it, what do you think board members would be an appropriate level?
I would actually probably defer to the current board on what we were currently spending, because it's really a product of the involvement that is gonna be required from him.
I would say 25,000 would be probably a reasonable start as a retainer. It's not too much, it's not too little either, so, because he's jumping in to probably work closely with the Rock Law Firm as well, so my recommendation would be to send over 25,000. Is there a motion to approve that?
I make a motion to approve the retainer to Trip Scott.
Okay, is there a second? Okay, any other questions, discussion on it? All right, all those in favor state so, to send 25,000 as a retainer to our new charter attorney state so by saying aye.
Aye.
Opposed? Passes unanimously. Any other board comments? I just had a question, when is the next assembly? Do you have one scheduled yet?
We do, we have one scheduled on Friday,
Okay.
and that will be for the upper school students. We will have hero, 9/11 hero, Mr. Tim Brown here.
Okay.
And he's making a stop here to talk about courage, citizenship, bravery. And he'll also be at another charter school on Marco Island later in the day.
That's wonderful.
It'll be awesome, and we're gonna get information out about it
Okay.
to the families.
That's amazing, and I'm glad we're doing something like that. I had a suggestion to recognize 2 of our parent volunteers that have been here all 5 years. You know, at the beginning of the school year, we gave out 5-year pins to our staff members and board members who've been here for 5 years, and we do have 2 parent volunteers who have been very dedicated to the school, and I thought it would be nice to honor them with a 5-year pin as well. So I don't, if that doesn't fit in on Friday, I understand, but if we could put that on and I would say probably for a lower school because their children are in the lower school, so it would be nice for them to see their parents recognized. So I'm just putting that out there, that I'd like to see that happen. And that's it.
And I just want to say that I think it's absolutely incredible that the false accusations of crimes have been used to attempt to threaten this board into legally extracted demands, and now that an actual crime has been committed, it's on the part of the people. Well, I thought Mr. White had said that a crime has been committed, we just don't know by whom.
That's correct.
I just think it's a very interesting turn of events.
Agreed. All right, anyone else? All right, if not, this meeting is adjourned. Thanks.